the house safety keeping rules for this hall. So to your left, you've got two exits. One is an
for
emergency.
this hall. So to your left, you've got.
Thank you. Um, as I was saying, we don't expect to have any emergencies this morning, and there will be no planned. There are no planned fire drills, but just in the unlikely event that we have to exit this hall, there are two exits to our left. One is behind the brown pillar there, and the other one is just by where the gentleman in white is standing. Same with the right side of the hall. You've got one exit and an emergency exit, so you can utilize any of these exits. The convenience downstairs, there is one for ladies and one for gentlemen. We want to say a big story for starting this event late. I think we are about 40 minutes into our time, and I'm hoping that we're going to start this. Our speakers are here. In fact, the keynote speaker has been online and been waiting for us, and we want to apologize for keeping you waiting, my Honorable Justice Galadima. We are going to start this shortly. So, ladies and gentlemen, my name is Benga Bello. I will be the anchor for this session of the program. This is ELLAN, the Employers and Lawyers Association of Nigeria. This is what we call the ELLAN Exchange, which is the flagship event of the association. This association itself started about 3 or 4 years ago by a group of young, energetic lawyers somewhere in Lagos Island. They were just starting to interrogate the new labor jurisprudence that the NIC has birthed on the legal trajectory of the Nigerian legal system. And it became very intense in terms of the kind of decisions that were coming from that court, and particularly the fact that it became a specialized court. And after all objections, it became very apparent that you have no choice but to go to this court for anything that has to do with employment, labor, trade unions, and the likes. Today, we are going to be having two sessions of the ELLAN Exchange. So the ELLAN Exchange for the first time is having two barrel sessions. The first session, which is going to start very soon, is going to discuss and is going to debate the NICN's adoption of international best practices and whether it is an unwarranted expansion of the labor law jurisprudence in Nigeria. The anchor is here, he's ready, and I will introduce him shortly. The second session will be looking at the three candidates who are contesting for the Nigerian Bar Association's presidency. In the Nigerian landscape, the Emiloko syndrome seemed to have overtaken the whole political atmosphere. And here we are. We have three gentlemen who are going to be contesting, and today they will be giving you an expose of their manifestos. And also you will find out that the current president has left a very big shoes for anybody to fill. And I'm sure as young practitioners, you want to see a continuation in that direction. So today you'll be hearing firsthand from the contestants, and it promises to be a very intensive, a very informative, very engaging, and of course it offers you the opportunity to also meet with one another. There are some blue chips here who are sponsors of this event, and as the program goes on, we will be calling them and be acknowledging them for their support. But what is important is, as practitioners, we have people here from diverse walks of life. There are HR professionals here as well. So you might have to interact during the tea break session. So quickly, we are going to be diving straight into it. I'm not going to take much of our time. I'm going to be inviting, he's joining us virtually from somewhere in the East. Our keynote speaker is a justice of the National Industrial Court of Nigeria. He is an ardent follower of happenings in ELLAN itself and is very pleased to join us today. Please welcome to give us the keynote address, Honorable Justice Ibrahim S. Galadima, Justice of the National Industrial Court Owerri Division. A round of applause for him.
Hello. Can I get confirmation that I can be heard or seen? Hello, can you hear me? Mr. Moderator, are you there? All right, I can. Hello, can you hear me?
Yes, we can hear you, my Lord.
Good morning. It's a pleasure to be here today. I'm happy to. Are you there? All right, I can. Hello, can you hear me?
Yes, we can hear you, my Lord.
Good morning. It's a pleasure to be here today. I'm happy to. Are you there? All right, I can. Hello, can you hear me?
Yes, we can hear you, my Lord.
Good morning. It's a pleasure to be here today. I probably was supposed to read the keynote speech. Hello, can you hear me?
Yes, we can hear you, my Lord.
Good morning. It's a pleasure to be here today. I probably was supposed to read the keynote speech. Hello, can you hear me?
Yes, we can hear you, my Lord.
Good morning. It's a pleasure to be here today. I probably was supposed to read the keynote speech. Hello, can you hear me?
Yes, we can hear you, my Lord.
I think I'm having some technical difficulties. I probably was supposed to read the keynote speech.
Yes, we can hear you, my Lord.
I think I'm having some technical difficulties. The keynote speech.
Yes, we can hear you, my Lord.
I think I'm having some technical difficulties. The keynote speech.
Yes, we can hear you, my Lord.
I think I'm having some technical difficulties. The keynote speech.
Yes, we can hear you, my Lord.
I think I'm having some technical difficulties. Good morning. Can you hear me now? All right. Please, without wasting more time, I think time has already been spent since we were supposed to have started.
Yes, my Lord.
More time. I think time has already been spent since we were supposed to have started.
Yes, my Lord.
More time. I think time has already been spent since we were supposed to have started.
Yes, my Lord.
I am poised to begin this address by observing that the terminology best practice. I am poised to begin this address by observing that the terminology best practice. I am poised susceptible to contextual meanings and definitions. That's the terminology best practice.
susceptible to contextual meanings and definitions. Prominently, what the best practice connotes largely depends on the context and endeavor is consideration. Largely depends on the context and endeavor is consideration. Largely depends. As such, best practices are recognized and operable in the fields of healthcare, mining, agriculture, governance, administration, etc. Now, evolving from time out of mind, best practices are believed by some scholars to have metamorphosed from ideas such as one best way or the benchmark, a universal concept applying to all human endeavors. A best practice is thus been defined to signify strategies, techniques, and methodologies that have been proven through research, long usage, and experiments to yield the desired results. Now, international best practices in labor and employment, a contextual understanding. My reference to international best practices in this address refers to the approved and recommended modus operandi in relation to employments, labor, and industrial relations. These practices share their sources from international laws, conventions, or declarations in that they originate from treaties, the resolutions of the International Labour Organization, general principles of employment law, customs, judicial decisions, and teachings. However, what may be recognized as a best practice today might not have had the same honor or place since times evolve and standards change. Within the Nigerian legal jurisprudence, international treaties and resolutions do not have the force of law unless and until they have been domesticated by the National Assembly. Section 12, sub 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, states clearly as follows, and I quote, "No treaty between the Federation and any other country shall have the force of law except to the extent which any such treaty has been enacted into law by the National Assembly." End of quote. Now, the Apex Court gave a constitutional interpretation of this provision in the case of Abacha versus Farahimi, citation supplied, while considering the applicability of the African Charter on Human and People's Rights, as adopted by the African Union, of which Nigeria is a member, on the 19th of January 1981. Now, in 1983, the National Assembly enacted the African Charter on Human and People's Rights, the Ratification and Enforcement Act. Delivering the lead judgment, His Lordship Michael Ekundayo Ogundare, JSC, as he then was, stated that, and I quote, "I have carefully considered all that has been said by learned counsel for the parties on the status of the Charter as an international treaty entered into by our country. I do not consider it necessary to set out in extenso in this judgment their submissions. Suffice to say that an international treaty entered into by the government of Nigeria does not become binding until enacted into law by the National Assembly." Now, the inapplicability of conventions and treaties that have not been ratified by Nigeria was again espoused by the Apex Court in the Medical and Health Workers Union of Nigeria versus the Minister of Health and Productivity and others, citation supplied, where it was held that the provisions of an ILO convention could not be invoked before a Nigerian court unless same has been enacted by the National Assembly. The jurisdiction of the National Industrial Court. Every Nigerian labor law student understands that the National Industrial Court of Nigeria was notionally created in 1976 to handle all labor and trade disputes amongst employers or with their employees, or between an employer and his employees, trade unions and employers, etc. After many years of controversy about the actual status of the court and its jurisdiction, it is now crystal clear and beyond peradventure that the National Industrial Court is a superior court of record, created and empowered under Section 254A and 254C of the Constitution of the Federal Republic of Nigeria, 1999, respectively, or the Third Alteration Act 2010. Now, specifically, Section 254C2 provides that, and I quote, notwithstanding anything to the contrary in this Constitution, the National Industrial Court shall have the jurisdiction and power to deal with any matter connected with or pertaining to the application of any international convention, treaty, or protocol of which Nigeria has ratified relating to labor, employment, workplace, industrial relations, or matters connected therewith. End of quote. In the case of Aero Contractors Company of Nigeria Limited versus the National Association of Aircraft Pilots and Engineers, NAAPE, citation supplied, His Lordship Kanyib J, as he then was, gave a discerning outlook on how Section 254C, CFR 1999, must be interpreted in relation to these court's powers to apply ratified labor conventions. Accordingly, there are two ways of approaching the issue at hand. The first is the question whether the Constitution, the Third Alteration Act 2010, which inserted Section 254C 1F and H, and especially subsection 2, is not the domestication demanded by Section 12 of the 1999 Constitution itself. I think it is. The Constitution, the Third Alteration Act 2010, amended the 1999 Constitution. Before it was passed and assented to by the President of the country, it was sent to all the houses of assembly in the Federation and was ratified by a majority of the houses of assembly, hence the alteration of the 1999 Constitution itself. This effectively means that the requirements of Section 12 of the 1999 Constitution were and have been made when Section 254C, 1F, and H, and Sub 2 were enacted as per the Constitution, Third Alteration Act 2010. Even if the first approach were not to be the case, the second approach at treating the issue is that both subsections 1 and 2 of Section 254C of the 1999 Constitution as amended commence with the word notwithstanding. In subsection 1, it is notwithstanding the provisions of sections 254, 251, 257, 272, and anything contained in this Constitution. And in subsection 2, it is notwithstanding anything to the contrary in this Constitution. Of subsection 2. Now, the use of the word notwithstanding in any statutory instrument has been judicially considered by the Supreme Court in Peter Obi versus INEC, where Pa Aderemi, JST, stated that when the term notwithstanding is used in a section of a statute, it is meant to exclude an impending or impending effect or any other provision of the statute or other subordinate legislation so that the said section may fulfill itself. In like manner, the use of the word notwithstanding in section 254C, sub 1F and H, and subsection 2 of the 1999 Constitution as amended is meant to exclude the impending effects of section 12 on any other section of the 1999 Constitution. It follows that as used in section 254C, sub 1F and H, and sub 2 of the 1999 Constitution as amended, no provision of the Constitution shall be capable of undermining the said section 254C, 1 sub F and H and 2, and I so find and hold. So, whichever of the two approaches is adopted, or even if both approaches are adopted, I have no hesitation whatsoever in finding and holding that this court has the jurisdiction and power to apply any international convention, treaty, or protocol of which Nigeria has ratified. Now, there is no gainsaying that a superior court of records cannot act in vacuum, as the exercise of its powers are circumscribed within its jurisdiction, as jurisdiction is the live wire of every adjudication. To say the least, jurisdiction is the power to exercise authority over subjects within one's territory. It is indeed the salt of every adjudicative delicacy. Now, the NICN's approach of international best practices. In order to understand the approach by the National Industrial Court of Nigeria in the adoption of international best practices, it is imperative to first and foremost come to terms with the formidable fact that the court is indubitably a specialized one. This is better captured in the words of the Nigerian labor titan, the Honorable Justice Bibi Kanyip, when he stated thus: the National Industrial Court is a specialized superior court of record for dispensing social justice, dedicated to administrating justice in an equitable, impartial, and timely manner, in accordance with the rule of law, and by fostering public trust, understanding, and confidence. Prior to its establishment and entrenchment in the Third Alteration Act 2010, the High Courts, which had original jurisdiction to try labor and employment matters, had no obligations whatsoever to apply and follow good international best practices. Only the NICN has been constitutionally bestowed with such attributes. As such, the court must be seen as a judicial engine for social engineering. The nature of matters within its exclusive civil jurisdiction inherently characterizes the court as a formidable institution for achieving labor justice, equity, and fairness in Nigeria. There is no doubt that matters concerning or relating to labor, employment, trade union, workplace environment, and or gender discrimination or inequality, etc., are salient and delicate matters deserving of judicial care and caution. A single decision of the court can cripple the entire economy of the nation or destabilize its social milieu. Hence, the court adopts measures, strategies, and innovations that could facilitate the attainment of labor justice, even if it derogates from other judicial principles. An instance is Section 12 of the National Industrial Court Act 2006, which provides as follows. Section 12, sub 2. Subject to this act and rules made thereunder, the court may A. regulate its procedure and proceedings as it thinks fit, and B. shall be bound by the Evidence Act, but may depart from it in the interest of justice. Again, Order 5, Rule 6, Sub 2 of the National Industrial Court Civil Procedure Rules 2017 also provides that in any proceeding pending before it, the court may, as a specialized court, A, regulate its procedures and proceedings as it thinks fit in the interest of justice and fair play, or B, in appropriate circumstances, depart from the Evidence Act as provided in Section 12, Sub 2B of the National Industrial Court Act 2006 in the interest of justice, fairness, equity, and fair play. Now, these provisions, as contained in the NIC Act and the rules, underscore the core and ultimate essence of the NICN, which is to meet the ends of employment and labor justice. Now, in the case of Aloysius versus Diamond Bank PLC, citation supplied, the NICN applied an International Labour Organization, ILO Convention, Termination of Employment Convention number 158 of 1982 in determining the rights and obligations of the parties. In that suit, the court presided by the Honorable Justice Kola Olalere held inter alia as follows. I quote, by the provisions of sections 254C, sub 1, F and H of the 1999 Constitution as amended, this court can now move away from the harsh and rigid common law posture of allowing an employer to terminate its employee for bad or for no reasons at all. I further hold that the reason given by the defendant for determining the claimant's employment in the instant case, which is that his service was no longer required, is not a valid one connected with the capacity or conduct of the claimant's duties in the defendant's bank. Now, the court also pronounced that, and I quote, the committee of experts of the ILO has frequently recalled in its comments that the need to base termination of employment on a valid reason is the cornerstone of the convention's provisions. This is the global position on employment relationship now. It is the current international labor standard and international best practice. Although this convention is not ratified by Nigeria, but since March 4, 2011, when the Constitution of the Federal Republic of Nigeria 1999, Third Alteration Act 2010 came into effect, this court has the power under the Constitution to apply international best practice and international labor standard to matters like this by virtue of Section 254C, sub 1, F and H of the Constitution. Now, it is notable that at the time the above decision was made, the International Convention 158 applied by the court was not ratified by the Nigerian government. So the NICN could apply international best practices given its unique jurisdiction under sections 254C, F and H of the Nigerian Constitution. It may also interest us to note that countries like the DR Congo, Morocco, Niger, and Namibia already ratified and utilized C-158, and so one wonders why this is yet to be done in Nigeria. So far, Nigeria has ratified 40 international labor conventions only according to available statistics from ILO. Again, on the application of international best practices by the NICN, the Court of Appeal had reason to hold that an international best practice can only be applied in a case where it was specifically pleaded by the party seeking to apply such provisions. This has been argued as constituting a gray area in the Aloysius case, Supra, where an international convention was relied on by the court despite not being pleaded by any of the parties. Now, the reason for the desired procedure as observed by the Court of Appeal is not far-fetched, since Section 7.6 of the NIC Act 2006 states as follows, and I quote, "The court shall, in exercising its jurisdiction or any of the powers conferred upon it by this act or any other enactment or law, have due regard to good or international best practices in labor or industrial relations, and what amounts to good or international best practice in labor or industrial relations shall be a question of facts." The position of the court, which accords with mine, therefore, is that although the ILO Convention 158, for instance, which is on termination, has not been ratified by Nigeria, we can still apply it only as evidence of good international best practice. Even here, it requires pleadings and proof. But because it has been so recognized by our courts, it may now apply in virtue of judicial precedence or judicial notice. This may be in contradistinction with my very, very erudite brothers, that's Kado J's position, in Bello Ibrahim versus EcoBank, citation supplied, wherein the court held that the dismissal of the claimant was wrongful as the defendant failed to comply with Convention 158, which is Termination of Employment Convention 1982, even though the parties did not specifically plead and or rely on the provisions of that convention during trial. By arriving at the right decision regardless, that judgment seems to have cemented His Lordship Ogaku's opinion in Sahara Energy Resources Limited versus Oyebola, citation supplied, that, I quote, "rules operate in all or nothing dimensions. Principles do not. Principles merely incline decisions one way or the other. The importance of this novel provision, in my differential view, is that the NICN is in considering the measure of quantum of damages is to do so in accordance with good or international best practices in labor or industrial relations, which shall be a question of facts." Conclusion. Now, ratification is the international act whereby a nation indicates its consent to be bound by a treaty, protocol, declaration, or convention. Now, insofar as a treaty or convention which forms or constitutes international best practices and standards has been ratified in accordance with the Constitution of the Federal Republic of Nigeria, 1999, as amended, the National Industrial Court is empowered to apply same directly in determining any matter within its jurisdiction. As such, even where a relevant international best practice is not specifically pleaded by either party, the NICN may raise same suo motu and call for legal submissions from counsel before its application. In the bid to achieve employment and labor justice, therefore, the National Industrial Court is probably the only court in Nigeria positioned to utilize its statutory bias in setting up faster and sustainable precedents in the dispute settlement mechanism of the entire country. I thank you all for listening.
We want to say a big thank you to Honorable Justice Ibrahim Galadima, Judge of the National Industrial Court, Owerri Division. That gives us that's the precursor to the debate which is going to start shortly. First, let me also apologize for the technical hitch we had at the beginning of the keynote address. The keynote address will be circulated to the emails which you have provided on your entry into this hall. And quickly, let me introduce to moderate the session, which is the first session of this ELLAN Exchange 2022, the motion that the NICN's adoption of international best practices is an unwarranted expansion of the labor law jurisprudence in Nigeria. He is a labor law expert. He is a partner in one of the blue chip law firms in Nigeria. Started his practice in the law firm of, I think it's Olushina Shofola and Co, if I'm correct. And today he's a partner in Perchstone and Grays. He's a senior advocate of Nigeria, and he's one of the most erudite writers whose writings will definitely excite and, invite comments from all and sundry. Welcome, my friend, Mr. Folabu Kuti, senior advocate of Nigeria. Thank you very much, Leonard, senior advocate. It's good to have you here. Please take your seat on the red chair. And to introduce the panel who is supporting the motion that international best practice or the adoption of international best practices by the National Industrial Court of Nigeria is an unwarranted expansion of the labor law jurisprudence of Nigeria. Erudite speakers, writers, teachers of law, lawyers of distinction in their own rights. Without, using the precedents, I'm just going to, make this as informal as possible so that we are not straitjacketed. The first in this panel supporting the motion is a professor of law. He lectured, I think, in 2 universities, which I don't want to mention the name so that I'm not running into the risk of defamation. And he's an erudite writer. He's a good speaker. He's made positions on the law of evidence in Nigeria, which a lot of us must have read, particularly on pre-Section 84 of the Evidence Act on the admissibility of computer-generated evidence. He's the principal of his firm. He's a senior advocate of Nigeria. Please welcome the erudite professor, Taiwo Oshikpiton, senior advocate of Nigeria, principal, Bayo Oshikpiton and Co. Please clap as he comes to the seat. In the team as well is an erudite lawyer, an amazing in the legal field in Nigeria, an astute litigator. She started her practice quite a few years ago, but everywhere she had been, she has left her footprints. I knew at one time she was a partner in the law firm of Austin Peters and Co. And I think when she left, I took over her seat. Today, she is partner in Banwo and Igodalo, a commercial law firm in Nigeria. Please welcome with me, Mrs. Abimbola Akeredolu, senior advocate of Nigeria. Thank you very much. And the last, not the least, in this team, when we had the first ELLAN debate, I had the privilege of having him in my team at the most prestigious office of the Udoma Sage, where we had the first one, I think in 2019 or so, was it 2016, sorry, when we had the first ELLAN Exchange. He was with me to support the motion on training bonds, on training bonds at that time. That was the topic of discussion. He's the managing partner of his law firm. He's not a senior advocate just yet, but I'm aware that he's in the line. Please welcome with me a fantastic labor law discussant, Mr. Farouk Abbas, managing partner, Abdul Salam Abbas and Co. You're welcome, sir. Thank you. And on the other side is the panel, which strongly advocates that the adoption of international best practices is warranted for the expansion, that is arguing against the motion which we have put forward before you. It's going to be tough because to introduce her without her profile is quite difficult. But you all know, if you've done labor law in Nigeria, there's no way you would not have come across her books or one of her books. She's the doyen of, she's what I would call a doyen in labor law jurisprudence in Nigeria. She's kept a consistent passion for developing the labor law jurisprudence in Nigeria through her books, through her teachings, through consultancy, and helping the National Industrial Court to come up with the framework that will define that court to today, prior to the establishment of the National Industrial Court as a court of record, all through when they were IAP, and meandering through the chastities of the challenges of treating trade unions disputes and individual employment disputes. She had been a guide to that court. Today we are privileged to have amongst us an erudite professor of law in Nigeria, and who I will call the first among the rest in labor law jurisprudence. Please welcome with me Professor Chioma Agomo, Professor of Law, University of Lagos. Please continue clapping until she comes to her seat. Thank you very much, ma. And what interests us is that at the time we made the overtures to her to come here, it was an acceptance without any conditions. Thank you very much, ma. To join her in leading this debate is a senior advocate of Nigeria, one of the young ones in this generation. I knew him when we started playing a football competition called the Bankolia Local Cup competition. And having seen him in court afterwards, I was not in doubt that we have one of the young chaps who will become leading lights in the legal profession in Nigeria. He is a partner in Aluko and Oyebode, leading a team of fantastic litigation lawyers. Please welcome Mr. Chukwuka Ikwazom, senior advocate of Nigeria. I told him this morning that he has started growing some gray hairs, and that is a testament of the fact that now the money has started coming in. To join them is a young practitioner, well, relatively young practitioner, one of those who will stir up debates on the ELLAN portal anytime it calls for it. And this he does unapologetically, because his views are considered quite, sometimes quite extreme. But you cannot but listen to him. Unfortunately, he's in-house, even though he started as a practitioner in the wig and gown. Today, he sits in the boardroom, guiding a blue chip company in the oil and gas industry through their legal procedures and processes. Please welcome to join in this debate, Mr. Emmanuel Wingate. He is a legal counsel, Here's Oil and Gas Holdings here in Lagos, Nigeria. You're welcome, Mr. Wingate. So, ladies and gentlemen, as it is our practice in ELLAN, so this is a debate, and I know that each of us seated here have our own approach or our own opinion on what you think about whether or not the adoption of international best practices is unwarranted in the expansion of the Nigerian labor law. And what we want to do is that we are going to have a vote right now amongst you. So please feel free to vote for us to know where you swing in this debate. The idea is this: at the end of the debate, we are going to check your swing again whether people are still in agreement with the position they had earlier taken, to know how this debate is. So what we are doing is that you are going to be gauging the arguments of the debaters to see whether you have been swayed by their arguments. That is the style. So right now we are going to project a link on the projector. All you need to do is impute that link into your phones, and as you vote, we are going to be seeing the slide. So it is a transparent process. You're going to see it. Once you vote, we are going to see the votes, going up. So please just start voting now before we start the debate. And I'm going to hand over to Mr. Folabi Kuti, SAN, who is going to moderate this session and give us the ground rules of the debate. Ladies and gentlemen, enjoy the debate.
Thank you. Thank you, Benga, for that healthy welcome introductions. I think it's only proper to, again, start with that. When you introduce Leonard Silk, Mrs. Akeredolu, that when she left Austin Peters, you took over a seat, I thought to myself that that's probably the only place that I wasn't aware that Benga worked. Benga has been all over. He's worked in the blue chip law firms. There's a blue chip law firms. And he's been in-house, house. There's anyone like that. So Benga, thank you very much for the introduction. A very good morning, everyone. I think it's an honor and a privilege to have been asked to moderate this session. I'm moderating a session where, again, I needed to correct. When Benga introduced Professor Agomo as Professor Agomo, something me said I should correct that emeritus Professor Agomo. Perhaps Professor Agomo, I would have been comfortable if you were introduced as Professor Agomo several years ago when I was in Part 2 Law, and then Labor Law was one of the elective courses I took. Professor Agomo was a Professor Agomo. Today is Emeritus Professor. So indeed, he's a doyen, and then we're honored to have you. A round of applause. It's only proper to start by thanking the Employment and Labor Lawyers Association of Nigeria for the courage to take the talk beyond the rich intellectual discussions that you get to follow. Okay, please, yes, please, just go ahead and cast your votes. Let's know where you swing. You can't swing both ways. It has to be either yes or no. We just need to take a poll on that. So, whilst we're at that, I was saying that it's only proper to thank the Employment and Labor Lawyers Association of Nigeria for having this public engagement, which
this is not a topic. We're not saying you can't adopt, but we're saying expansion, unwarranted expansion.
No, I'll correct it. No problem. I'll correct it. Apologies. Sorry. Oh, okay. Yeah, well, what you're voting for, saying yes or no, the topic or the debate, the theme is really the adoption of international best practices by the National Industrial Court of Nigeria is an unwarranted expansion of labor law jurisprudence. Do you agree or not? I am not sure whether you can surmise that within what is being displayed, but let me repeat, the debate today is on the adoption of international IBP in the literal sense, international best practices by the National Industrial Court of Nigeria is an unwarranted expansion of labor law jurisprudence. Do you agree or not? And then we'll return, cast your vote now, we'll take a poll and then we'll return by the time we're done with the great insights that the debaters would offer for or against the topic. So back to what I was saying about ELLAN having this. It is indeed commendable that and laudable that ELLAN decided to take beyond that WhatsApp group where you get to follow rich intellectual discussions generally to indeed have a sort of a public engagement, which this Oxford Davos style hybrid debate is all about. And today, you can be rest assured that it's quite, there's a lot to take away from it, learn from, agree or disagree with. And I'm privileged to have been asked to sit in and simply just not coordinate, moderate the session whilst we listen to the debaters. Please, a round of applause for ELLAN. A round of applause. And indeed, as Benga said, you would have to indulge me a bit. It is going to be participatory. I won't be asking you to be clapping all the time, but I would expect that you follow, you listen, evaluate the argument pro and against, and at the end of the day, we will rely on your judgment to make a decision one way or the other. The winner, you will determine the winner. We are just sitting here to listen and then let the debaters take out the points. You are going to determine that at the end of the day, the winner. And perhaps it's important to also mention that when I mention the winner, I use that loosely. The objective is not exactly to have a winner, but it's to promote engagement, it's to promote debate, it's to promote insight as to what the National Industrial Court is doing, and by so doing, help to deepen the jurisprudence one way or the other. So, in saying that, it's also important to mention that everything you hear here, please, take the content in the context of the debate. I repeat that. Take the content in the context of the debate. Whatever the debaters say, the viewpoints, the perspective offer may not necessarily represent their individual opinion or perspective as to the otherwise laudable adjudicatory work that the National Industrial Court is doing in the labor space. Again, I welcome you. We're in for a great time. Thank you very much. All right. Jury is still out. Is the verdict in? The poll. Any indication? Fantastic. All right. So I believe that what I read out, those who voted in the affirmative, in the affirmative today, indeed agree that what the industrial court is doing in applying high blood pressure, high international best practices is an unwarranted expansion of labor law jurisprudence. It appears that the votes, oh, you're voting in line with what is. Okay, there's a protestation there that what I read out is not exactly what is written there. But let me see. Arguably, it's almost the same. Is the National Industrial Court correct in adopting international? Yes. Yes. Prof corrected me that 7 up and 7 up. You can turn one upside down. Okay, for the purpose of this, and I'm sure technically, I don't know where this is coming from, but let's continue. But it appears that 52% of those seated in this hall, ordinarily they seem against the National Industrial Court. They seem in support of the national. Plus a round of applause for what you did. Okay. So now I understand Mrs. Akeredolu SAN's protestation. You all seem to lean towards Professor Agomo. Anyway, we'll come back to that. Oxford style. There's an opening, Oxford style parliamentary. It's an hybrid. Parliamentary, yes, an hybrid. The opening statement and the argument in support of the motion. Let me read out the motion again. The NIC's adoption of international best practices is an unwarranted expansion of the labor law jurisprudence. That's the motion. And leading the argument in support of that proposition, the lead speaker, Professor Taiwo Shipiton SAN, would have 8 minutes. 3 minutes to make opening statement, 5 minutes to get into the meat of the argument in itself. And please, like I said, we're looking to you, we're coming back to you to know whether you are convinced with whatever Prof is coming to say. I mean, well, I went to public school, public primary school, and back in those days, we were like, I hope you will be convinced and not confused by somebody who went to the same school too, like already. Yeah, so that's why we want to listen to Prof. Then, immediately after that, we'll come to the lead speaker for those against that proposition, and that's Professor Agomo. And by the way, when I issued the disclaimer, what I told Professor Agomo earlier today is that the disclaimer relates to every other person speaking here. The disclaimer doesn't relate to Professor Agomo. Predictably, whatever Prof is coming to say is our views about the court. So, and then we'll have Prof have the same 8 minutes, and then we'll go round and come back to Ms. Akeredolu SAN, ably supporting the proposition, and it goes around that sequence. So, Prof, I honored to have you, sir.
The moderator, co-debaters, we are debating, Oxford debate. My members of my team, distinguished audience, thanks for the amendment that came late in terms of the topic. Our topic is quite clear. It's reflected on the board. And we're here to persuade you, not to confuse you, that NICN has adopted, let me also have a caveat, that we had no hand in the choice of the topic. We also had no hand whether to belong to Team A or to Team B. Folabi and his team, in their wisdom, said we should do justice to the question. If I find myself in Team B, I will also argue that way. But today, I am putting on the cap as an advocate of Team A. The only regret I have is that, or I noticed that not too many people are from the employer side. Many of you are defending the employees. So the playing field is not level, but we'll try and level it today. Now, NICN has adopted international best practice, and our contention is that it's unwarranted expansion of labor law jurisprudence. Let me confess that the word unwarranted is a very strong word, but it has many meanings, many faces. Unwarranted means baseless, groundless. Those are strong words. We are very mild. We're looking at it from the point of view of being unfair, not well thought out, not well reasoned. These are the key words. So we will proceed from the aspect of it's being unfair. It's being not well thought out. It's being like a fire brigade approach. And it's being based on wholesale application of protocols, treaties that have not been domesticated, as well as customary international law, which is a question of fact, like customary law, move from time to time, change from place to place, and so on and so forth. In discharging that duty, we are approaching it dimensions. One, from the law of evidence, which is my own pet area. I'll welcome you to that area very soon. Also, from what they call judicial precedents. Every student of legal system in Nigeria knows about judicial system precedent. That certainty is the backbone of judicial precedent. Today, we have conflicting decisions from NIC, courtesy of international labor law best practice. You have to vote for certainty or uncertainty. As a lawyer, you want to advise your clients, you are uncertain. And when you go there, you advise, and you go to court and lose. You lose face with your clients. And if they are foreign clients, of course, they will say, what the hell is happening in your jurisdiction? You can give an alibi that I advise you on the law as it was when I give the advice. But then there's a paradigm shift. They will say, why is your law changing like somebody changing underwear? Or why is your law as unpredictable as the British weather? You know, in England, it can be sunny now, next moment, rain, without any notice to you. So we'll look at it from judicial precedent, which is the cornerstone of our legal system. Finally, we look at the issue of treaties, particularly section 254C2 of the Constitution, as it conflicts with section 12, namely, whether domesticated or not. Somebody is telling me that a protocol that has not been localized, that has not been domesticated, we must apply it. We must also apply best practices of courts, also of jurisdictions, where what they have as a forum for settling disputes is not courts. They have industrial arbitration panel, labor relations panel, conciliation, mediation. These are the machineries through which issues are sorted out. And I stand to say that you are either a court or you are not a court. It took NIC from 3 more minutes. I'm yet to take off. It took them how many years to transit from court in court, to court of superior record, 1976 to 2010. Somebody should calculate it. Now that you are a court, you are still going back to what people are doing in panel. Forward ever, backward never. That is the message for NIC. So let's quickly look at the evidence. I hear and I see section 12 of the NIC Act says that this court shall be bound by evidence. A little to the left. But in the interest of justice, you can depart from evidence. You give with the left hand, take away with the right hand. Where do you stand? You are just standing on the fence. Then justice according to whose standard? If your father is an employer of labor and you become a judge, your sympathy will be for the employer. If your father is an employee, was employed and oppressed by his employer, you become a judge, your sympathy will be. It's like somebody raping a daughter of a judge, and the judge has 4 daughters and one son, and you rape. Hey, the result is predictable. You will interpret it in such a way that you bend over backwards. So we are saying that this kind of thing allows for individual idiosyncrasies, whereas what we are asking for is certainty in the law. But this same NIC Act, in its rules, and indeed, the recently passed direction that came into force, is coming out strongly on evidence. It says that if you don't mark your documents the way you should mark them in your front-loaded documents and the relevant pages, as a plaintiff, your case can be struck out. Hello, somebody? That is evidence. Evidence in the very, very hard way. You say you don't want evidence, you are still embracing it in the hard way. And I have news for you. Under Section 256 of the Evidence Act, which came into force after Section 12 of NIC Act, it says that this Evidence Act will not apply before arbitrators. It will not apply before General Court Martial, but will apply before every court of record. And I ask you, if you say you're not applying Evidence Act, let me ask judges of Court of Appeal, NIC, if they are here, whether they want, whether going by 2561 of the Evidence Act, they are courts or arbitrators. Their answers will show that we want to be courts. We want to wear our wig and gown. We want to go on every conference that judges go for. We don't want to deal with arbitrators. Ladies and gentlemen, we must make up our mind. You are either there or you are not there. You cannot sit on the fence. You are either being a court and applying all the rules that apply to courts, or go back to where you are coming from as an industrial arbitration panel or a court or an inferior court, not of superior record. But having attained that level of superior court of record, whatever applies in federal high court should apply, and state high court should apply to industrial court. Once a court, always a court. No categories of courts. The playing field will be level. On that note, I want to rest my case for now. Thank you.
Please keep clapping. Not sure I mentioned that, not only will we be relying on you for the verdict, there's an opportunity to ask questions. So please, it's important that the questions or whatever issues arising from the submissions for against the proposition, there is an opportunity to pose the questions when the time comes, and we would call on you to ask the questions or make comments as you may probably feel like. Mr. Shehu Mustafa was clapping all along for Prof. And it's so easy to surmise that it appears that indeed not too happy with the subjective, which is what Prof has said, the subjective applicability of the Evidence Act, the industrial court, the propriety, also part of what Prof has introduced, the propriety of applying conventions, treaties that we cannot tell have been domesticated. I'll be good enough time to ask questions, and we'll come to that. Prof, I really want to ask that when the time comes, I will be asking what defines the Superior Court of Record is the rationale of being able to apply the Evidence Act. And before I do that, I am not in any doubt that Professor Agomo is up to the task. And then, as I respectfully call on Prof. Agomo, Emeritus Professor Agomo. A round of applause, please.
Let me follow protocol. Honorable Moderator, co-debaters, and honorable movers of the motion. Where is accurate timekeeper? Members of the audience, it's my pleasure. I'm here to oppose the motion that the NICN's adoption of international best practices is an unwarranted expansion of the labor jurisprudence. And the proposer has said unwarranted. Yes, it's strong, but that's not the sense in which they are using it. That's his own interpretation. If you look at the dictionary meaning of unwarranted, it says it means lacking a good reason, unnecessary, not justified or authorized. If you describe something as unwarranted, you are critical of it because you are saying there is no need or reason for it. You are saying it lacks adequate official support. Synonyms: insupportable, inexcusable, indefensible. So can we in all honesty say that NICN's adoption of international best practices is an inexcusable, is an unsupportable, it's a baseless. Maybe they are on a frolic of their own. That's what he's saying. It's not well thought out. So they're on a frolic of their own. So, and there's also the issue that you're talking at from the point of view of evidence. I want us to be clear about what we're talking about, because let's separate two issues here. One, does the NICN have the legal authority, right, to apply international best practices? That's the main issue. That is the main issue. We should not lose sight of that fact. Then the issue of evidence is, if it has a right, is it doing it the right way or the way it should do it? We must never merge the two. One is substantive. The other, who says procedural. So, does the NIC have the right? The answer is yes. It's already been said. The autochthonous constitution, our constitution of the Federal Republic of Nigeria, the grand norm of the law, gives the National Industrial Court the authority to apply international best practices in matters relating to employment, labor, and related issues. It has exclusive jurisdiction. It's the Constitution of 1999 as amended by the Third Alteration Act. It was not smuggled in. Whereas in 2006, the National Industrial Court Act was passed, and the National Industrial Court tried to use it to expand its jurisdiction. The Supreme Court shut it down and said, unless there's a constitutional amendment, you cannot apply it. Then went back and got that constitutional amendment. It followed through, all through procedures, and they got it. The only issue, as I said, the legal community was caught napping because they thought it would never happen. And they woke up, and suddenly, what was called the Industrial Arbitration Panel, the ugly duckling, and nobody wanted to touch, had become a beautiful bride, a court of superior record. 3 more minutes I have, so I want to lay the foundation. That's it. It has the legal right. Why? Put it. Because labor law is not like any other law. Labor law is a hybrid law. Labor law covers politics, economics, psychology, you name it. And besides, the traditional concepts that govern labor law have collapsed. Globalization of labor means no man, no country is an island. So you must have to apply international standards. If you want to be part of that community, there are no more borders. So we are going to be taking it from there. I've established that it has the legal rights and it's not on a frolic of its own. It's not fishing anything. It is doing what it's supposed to be doing. But whether it's doing it the way it should be done, that's another thing. We'll still come back to it. Thank you.
I'm not sure that is resounding enough. Because Prof was not just very articulate in the thoughts, but reminded me of when I mentioned public education, early education the other time. We had the opportunity of taking the podium to argue Proposition 4 against, but not only did we demonstrate with whatever advocacy that could come out from the mouth, but also there's some drama to it. Prof had good enough effect to sell the point that what the industrial court is doing is on firm ground. Jury is still out. At this point, I'll call on Mrs. Akeredolu saying, Team Hay, I haven't listened to the lead speaker. We are also calling on another consummate advocate. I don't know. Have you seen Mrs. Akeredolu in court? Oh, you said, okay, sorry. Farouk. Have you seen Farouk in court? You've seen him in court? Okay. So you'll probably say we should step down, not let him come on stage. A privilege to also invite on stage to support the proposition. I haven't heard from the lead speaker, Mr. Farouk Abbas. A round of applause, please.
Good afternoon, everyone. Good afternoon, Leonard Silks and professors and the interesting audience. I was going straight away, riding on the back of what Professor Oshikweton had said, and I will try to respond a little bit to what the learned Amazon has said as well. I need to take us historically. When the NIC became a superior court of record, what happened? In the case of National Union of Electricity Employees and BPE, the issue in that case wasn't whether the NIC could apply international best practices or whether they could apply treaties or convention, ratified or not ratified. The issue was that the NIC was not a superior court of record. It was an inferior court of record. Therefore, for this court to have jurisdiction over labor matters and all of these, they need to be recognized in the Constitution. Riding on the back of that decision of the Supreme Court, the Third Arbitration Act was introduced. And if you look at the introduction of the law, it is clear the primary reason for that statute was to make the NIC a superior court of record. The Supreme Court did not talk about international best practice or what have you. But now, in making that amendment, other things were, I don't want to use smuggled, I don't want to use brought in, but other things were brought in. Other issues were brought in. And if you have looked at the trajectory of our law reports, you will see that international best practices is not the only controversial issue in the Third Arbitration Amendment. I have been involved in one or two cases on other sections of that, but I won't go into that. So now, Section 254C2, 254C1, F and H says that the National Industrial Court can apply international best practices and standards and conventions, protocols that have been ratified. And I was glad to listen to the Justice's opening remarks. He further expanded it in his speech. Because initially, there were two positions. The first position was applying ratified conventions that are yet to be domesticated. The second position from our side is placing ratified conventions but undomesticated above local statutes. But the third position that was introduced by the learned justice is that once a convention is not ratified, you can now go and hide under the umbrella of international international best practices to now apply a convention that is yet to be ratified. What does Section 254C say? 2 says. It says it clearly. They will apply any matter connected with or pertaining to the application of any international convention, treaty, or protocol of which Nigeria has ratified. Our argument, ratified. Our argument is that when this section was introduced, it didn't say Section 12 has been nullified. Section 12 simply says that before you can apply a convention or a treaty in Nigeria, it must be domesticated. And there's a Supreme Court decision that interpreted that section, Abacha and Fawemi. And in that case, the Supreme Court adopted a convention, African People's Charter, that has been domesticated. So the law is clear on that. And when you're interpreting the Constitution in FRN and Osawon, in Skybank and Iwu, the Supreme Court said it clearly. You interpret the Constitution in a holistic manner. And you don't interpret the Constitution in a manner in which you delete another provision. If you follow what the learned prof has just said, by interpreting Section 254C to say you can go and choose international best practices, whether they recognize LGBT or whatever, or any kind of practices, and you bring it into Nigeria, what you are indirectly saying is that you are contradicting Section 12. The Section 254C2 did not say that conventions do not need to be domesticated. It only says you can apply ratified treaties. And because the draftsmen are aware of the historical knowledge of the Constitution, their own assumption and their intention is that you must also ensure that those treaties are ratified and domesticated. Once they are not domesticated, the NIC has no business whatsoever in bringing it. And I'll refer you to a particular case of the Court of Appeal. In the case of Oak Pension versus Olayinka, when the Supreme Court of Appeal talked about Section 254C2, 1A, F, G, H, and Section 19 of the NIC Act, it now went further and said, however, it should be noted that the constitutional jurisdiction and the statutory discretion vested in the trial courts by the sections are not at large to be exercised in the name of unfair labor practices or international best practice, abstractly, without regard to established facts of the case and the relevant principles of the law applicable to them. International best practice is not something you just apply without having regard to our law. I will give you a particular case, the case of Aero Contractor and the National Union of Airports and Engineers in the aviation sector. In that case, the Trade Union Act and the Trade Dispute Act defines who essential service providers are. And they say that if you are in the aviation sector, you are an essential service provider, and you can't go on strike. But in this case, the NIC relied on ILO Convention 87 and 98, which says that essential service providers are only air traffic officers, not all aviation workers. Therefore, the NIC relied on ILO Convention 87 and 98 and held that those pilots and engineers were not essential service providers. Even when our Trade Union Acts and Trade Dispute Acts state it categorically. In point of fact, this Trade Union Act has been endorsed by the Supreme Court. In the case of National Union of Electricity Employees and BPE, they endorsed that provision and said electricity workers are essential service providers. Now the NIC now went ahead and said local statute made by National Assembly is not relevant. I will go to ILO Convention. It's not logical. Let me give you one more point. If you say for the sake of argument, oh, I'm so sorry.
I'm sure you remember in introducing him, I asked if we've ever seen him in court. Did they argue? But of course, subject to the overriding wisdom of the judge at the end of the day. So he wanted more minutes. A round of applause again for Mr. Farrakhan. Fantastic point. Fantastic point. And worth taking. He made reference to what Honorable Justice Galadima said in the opening remarks. Again, leaned on the interpretation that has been given to the need to locally intervene by legislation on any foreign treaty convention before it can be applicable, and relying heavily on Abacha and Fawemi. Noguda rejects its position there, but of course, I think the only thing that was smart, he didn't go further to make reference to the fact that the same Justice Galadima also said that Honorable Justice Kanye, in one or two decisions, interestingly referred to one, Aero Contractor, had also said that the opening word to Section 254 says notwithstanding. Sorry, my lord. Well, I'm not the one to make the decision. Apologies. Apologies. Again, a round of applause for those proposing. A round of applause. And I'm sure you are nodding high. Apologies. At this stage, let me invite to the podium. Well, Benga seemed carried away describing the young, energetic, and all the necessary adjectives. But what you forgot to add is that Chuka Kwazom, emeritus former chairman of the Lagos Bar. A round of applause for that.
Thank you very much. Good afternoon, ladies and gentlemen. Very quickly, I would like to support Professor Gomo in redirecting our minds to the topic of the debate. Anyone who is a good debater will recognize that when you do not have arguments, you try to change the topic. But we're not going to let that happen. The topic of this debate is whether the adoption by the NIC of international best practices is unwarranted. And I stand here to say that it is not unwarranted. Whether or not you're looking at the word unwarranted from the standpoint of whether it is legal, or you're looking at it from the standpoint of whether it is desirable, I'll say that in both instances, it is not unwarranted. Now, the last speaker on the other side made the point that the Section 12 of the Constitution provides that undomesticated treaties cannot have force of law in Nigeria. But what he did not tell you is that Section 254C starts with the opening phrase, notwithstanding anything in Section 257, 272, or any other provision of this Constitution. That introductory phrase makes it clear that every other section of the Constitution that has a contrary provision is subjected to Section 254C. So there cannot be an argument about the validity, the legal validity of the exercise of that jurisdiction. Now, with respect to the desirability of the adoption of international best practices, perhaps the best place to start is to look at what was the jurisprudence, labor law jurisprudence before the third alteration. Now, there are different sources of labor law, but I would like to focus on the primary sources. The first being labor statutes. Nigeria had and still has labor statutes that are archaic and outmoded. The Labor Act was enacted in 1971, 52 years ago. There has not been any substantive amendment to it. The Labor Disputes Act and the Trade Unions Act were enacted in 1973, almost 50 years ago. The second source, we always talk about the common law. The common law as a source of law refers to law, judge-made law that was formulated by the old common law courts from the traditions of Englishmen. Long before the adoption of international best practice, right? Even the English legislature has intervened to amend some of the applicable common law principles, but we're still stuck on those common law provisions in Nigeria. What about the other source, which is the conventions? Nigeria has ratified many conventions of the ILO, but how many of them are applicable in Nigeria? Many of them are not, either because they have not been ratified at all, or because they were ratified and not domesticated. How can we say that an intervention, a constitutional intervention that has given the NIC the right and the authority to apply practices that are practiced in other civilized jurisdictions is unwarranted in light of the archaic laws that we have in Nigeria? How can we say that? The second point is that we must realize that things have changed. Labor law has moved far from what used to be the master-servant relationship articulated and formulated under the common law. Today, if as a country you do not manage labor relations effectively, you're likely to compromise your stability, your growth, your development. So that is why it is important that we're not stuck with archaic principles of, like the common law. We move progressively. What is more, the adoption of international best practices ensures that there are no discriminatory practices. Because we know that state borders are fast disappearing because of globalization, right? And many multinational enterprises no longer have states. They are stateless. So what happens is you have a multinational company that has employees in Nigeria. Because we are applying a KE clause, the Nigerian employees of that multinational are getting a different treatment from the treatment that other employees of that multinational are getting in advanced countries that are applying progressive laws. That cannot be right. That cannot be right at all. So I stand here to say that whichever way you look at it, whether you look at it from the point of view of legality or from the point of view of desirability, there is no argument to support the proposition that the adoption of international best practices is unwarranted. Thank you very much.
Let me ask for another round of applause for Mr. Kwazome SAN's very insightful perspective on what the industrial court is doing in today's world of work. Well, let me call on, by no means the least or the last speaker for Team A in support of the proposition, Mrs. Akeredolu SAN. A round of applause.
Thank you very much, my co-debaters, distinguished audience, and the timekeeper. I'll keep an eye on you. Thank you. I need to make a clarification. We are not saying that the NIC's adoption of international labor practice is totally unwarranted. We are saying it's an unwarranted expansion. The last speaker spoke to unwarranted. We are saying on an unwarranted expansion of the labor jurisprudence in Nigeria. My brief is to speak to the impact of this unwarranted expansion on case law. The NICN has relied on the provisions of Section 254C, 1F and H of the Constitution and Section 76 of the Industrial NIC Act, which enjoins the NICN to have due regard to fair labor practices and to good or international best practices in labor, employment, and industrial relations when exercising its exclusive jurisdiction over labor and employment. And the court did this in James Adekunle Wulade against Nigeria Ajip Oil Company Limited, an unreported case of the NIC. And in that case, the court said the provisions of Section 254(1)(f) of the Constitution and Section 76 of the NICN operates to set international best practice and standards in labor relations as the benchmark against which labor and industrial relations in Nigeria are to be measured. But this position of the NIC directly contrasts with the decision of the Supreme Court in the case of Chukwuma and Shell Petroleum Development Company, which for many years has been the locus classicus on employment, ordinary master-servant employment decisions. Thank you. And also the case of Obanye and Union Bank of Nigeria. So what has happened with the passing of these laws is there's been a paradigm shift. But the paradigm shift itself would not have been a problem if there were established guardrails and legal guidelines on the application of international best practice. The unfortunate consequence of the absence of guardrails and guidelines in this regard is that it has led to a trend of inconsistencies and conflicting decisions from the courts. There's now no clear pattern or established principle by which to be guided in advising clients in labor relations matters. The unwarranted expansion of labor law jurisprudence is seen in numerous instances of conflicting NICN decisions. For example, in Bello, the NIC took opposing views on the issue of reinstatement after termination of employment in Bello Ibrahim against Ecobank, which was referred to by the keynote speaker. And also in the case of Clement Abayomi Unitiju against Lekki Concession Company. In both cases, the claimant's employments were terminated for no reason. And the court agreed that the termination was unfair and wrong. However, in the Bello case, NIC Abuja ordered the claimant's reinstatement. But 1 year earlier in the Lekki case, NICN Lagos had taken the opposite view and held that although the termination was wrongful, the claimant's employment had been terminated in line with the common law position. In the recent case of Emma Edet against Fidelity Bank, which was incidentally delivered the same day as the Bello case, though by different judges, the NICN declined to reinstate the claimant or to award exemplary damages. It appears now the many conflicting decisions of the NIC in similar issues testifies to and further buttresses the motion that the way the NICN has adopted and continues to adopt international labor best practices has birthed an unwarranted and indeed complicated expansion of the labor law jurisprudence. It appears now that the application of international best practices is guided by the size of the chancellor's foot, an English concept of medieval antiquity, which we should best depart from. I come to the issue of notwithstanding. Anyway, I will do that in my closing remarks. I also have time for closing remarks. Yes. The divergence of judicial decisions and subjectiveness of judges in applying international best practices raises a further pertinent point. What exactly are the constituents of said international best practices? Are their categories closed? Is there a manual or guidebook to which judges or concerned stakeholders can have resort for directions when international best practice is to be applied? Or do the judges just make them as they go along? As one of my co-debaters said, if if a judge has an employer background, his mindset is going to be naturally shifted to supporting employers. If he has an employee mindset, ditto, it goes the same way. These questions beg for answers, and until they are resolved in the interest of the general good, the motion remains solid. I have another 5 minutes. The motion remains solid that the NICN's adoption of international labor practices is an unwarranted expansion of labor law in Nigeria. So I'm going to round up.
In football, there's something called injury.
I have time to round up.
Yes, please, yes. Don't worry. My discretion. The injury time, I would have thought the last speaker for today.
Oh, there you go. Thank you.
So that I won't be passive.
So I come to the hallowed principle of the doctrine of judicial precedent, which is expressed in the Latin phrase stare decisis. Decisions of the Supreme Court and those of the Court of Appeal are strictly binding on the NICN. And any refusal by the NICN to abide by or follow the binding decisions of the Superior Court will amount to judicial activism of an aberrant sort. There's another word I've used, but I will refrain. The principle, and in the case of Lead Merchant Bank against PTF, the Court of Appeal said, the principle of stare decisis has imposed an obligation on lower courts to be bound by the decisions of higher courts. Deliberate refusal to be so bound amounts to judicial impertinence, which is capable of enthroning judicial rascality and anarchy in the judicial hierarchy. This must be discouraged by judges. What's the importation, the unwarranted expansion of the labor law jurisprudence in Nigeria has engendered is a departure from judicial precedent. What we now have, which I will quickly summarize, is that now ordinary masters, we were taught previously that ordinary master employment with statutory flavor enjoys more protection of the law than ordinary master servant employment. Nowadays, what you have with the importation, the unwarranted expansion of international best practice is that ordinary master servant employment is now enjoying the same stature as statutory flavor without any legal precedent. Thank you. The whole foundation of gaining a legal education in our universities and law school is premised on the principle of judicial precedent. It is the judicial precedent that was handed down by the courts that we imbibe from our law teachers' textbooks and practice texts. We have two of our teachers here. Our teachers saying that the law that we were taught in the University of Lagos should be put aside and let us employ instead international best practice. Surely, I do believe the speaker is not saying that. I will quickly summarize our position from the first speaker. So the position of the first speaker is that the Evidence Act is applicable by the NICN by virtue of Section 12(2)(b) of the NICN Act and Section 256 of the Constitution. All to be read along with Section 6 of the Constitution, which confers the status of Superior Court of Record on the NIC. The provisions of Section 12(2)(b) of the NICN Act, which allows the NICN to dispense with the application of Evidence Act in the interest of justice, is rather unfortunate. The phrase interest of justice is open-ended. NICN is a court, therefore, it must apply rules of evidence and the Evidence Act as applied by other courts of superior record in Nigeria. Dispensing with the provisions of Evidence Act in the interest of justice gives the wrong impression that the NICN is more of an arbitral tribunal or panel than a court. The phrase interest of justice lacks precision and has led and will still lead to confusion in its application by judges of the NICN. Best labor practice and unfair labor practice are also loose terms that are not precise. Where they are not contained in any convention or protocol, they operate as rules of customary international law. Consequently, they are questions of fact, with which its proponents under the NICN, Civil Procedure Rules of 2017, are expected to plead and prove through relevant evidence in the same way that Nigerian customary law is proved in court. Expert witnesses will then be required to prove them, and such witnesses, where available, demand handsome fees from the party hiring them. My co-debaters, a summary of my co-debaters' views is that Section 254C, 1F and H of the Constitution gives the Federal NICN exclusive jurisdiction relating to or unconnected with unfair labor practice or international best practices in labor, employment, industrial relations matters. So, their interpretation of the Constitution has introduced a departure from well-established provisions of the law and jurisprudence regarding the application of treaties and conventions. This is because Section 12 of the Constitution provides that no treaty between the Federation and any other country shall have the force of law except to the extent to which any such treaty has been enacted into law by the National Assembly. And we are aware that the treaty in contention here has not been enacted into law by the National Assembly. Section 254C, 2 of the Constitution has not dispensed with the need for a treaty to be domesticated before it can be applied by the NICN in Nigeria. Because that section does not outrightly state that domestication of a treaty is no longer mandatory before it can be applied in Nigeria. International best practice is an unruly horse and would be and is difficult to apply because you cannot even make it out. You can only apply a concept that you fully understand. So how do we differentiate between a judge's opinion and international best practice? Distinguished ladies and gentlemen, I do hope that we have been able to convince you that the NICN's adoption of international labor practice is an unwarranted expansion of the labor law jurisprudence in Nigeria. Thank you.
Please, I need us to keep clapping. And I thank the learned Sec, Mr. Kredelo saying I wasn't disappointed. I need to explain. She took longer time because I'm told that she would have to leave shortly, and then had to also take the closing remark, the 3 minutes that the team would have. So that was taken in addition to that. It appears they've exhausted whatever timeline they have to make the debate. Please, a round of applause again. Very articulate thoughts. She cut straight to chase. It is an starting with making a distinction between warranted and unwarranted. And context is actually very important at every point in time that we bite at any discussion that we take a differing opinion from the other side. But before I call on the last speaker, let me just quickly, there's some small anecdotes around what Ms. Akeredolu SAN said when she resisted calling or using a harsh word for the lower courts, not wanting to be bound by the superior court. You did say that you rather not use any word. Let me just tell some small anecdotes. So 2003, I was in this election petition somewhere in Jos. I was a junior to Chief Shofola SAN, and a matter was called. We stood down her matter, and then some other election petition matter was called. And the counsel to the petitioner got up to tell the court. The panel was led by the Honorable Justice Akisoya, who is now deceased, Dolapo Akisoya. And they said that, he was only there to inform the court that his filed an appeal and also asked for stay of execution or stay of proceedings. And that I hope that the courts, the tribunal will know that it would amount to judicial rascality to continue to go on. And then one of the panel shot at him that, are you telling us that we are rascals? He said, my lord, I didn't say so. Supreme Court in Muhammad Wumi said that is judicial impertinence for you to have continued. I'm not the one. Please let me hide this Supreme Court who said in Muhammad that will be amount to judicial. Me? Who am I? I cannot say that. A round of applause again for Joseph. I'm going to wing it. I used to know very much as a consummate courtroom advocate several years back. And I think we had 1 or 2 matters together. And then the next thing, I didn't see him around court. I learned that he's jumped ship to cross to in-house. So I won't be disappointed. He's here to take on and support the view that what the industrial court is doing in exploring high blood pressure for practitioners before the court is just the right thing. Please come around.
Thank you very much. May I stand on already existing protocol? First off, how many ordinary servants do we have here? So, I mean, I am not a servant. I am an employee in accordance with global standards. The master-servant relationship of those days, of the common law days, which is what it was. What we know as employees, they used to be servants with little or no rights. That means the employer came in and said, oh yeah, off with you. You say, oh, no, perhaps you are a female employee, they've touched you something. I say, in any case, go. And there was nothing you could do because they call it the right to what? Hire and fire. So that is no longer the case. We are no longer servants, we are now employees. And this has changed because this common law position has changed, even from the common law itself, even in the established common law jurisdictions that we inherited the common law from. I do not mean that there was that legislature changed that rule. All I mean is that the common law in its natural, in the way it naturally evolved, because it is what? Is common law no longer a judgment rule? Yes, common law is judgment. So that is why as far back as 1972 in the United Kingdom, the English courts held that in some circumstances, employees could be reinstated. There was no statute. They could be, and that is what, so when we say there are conflicting decisions of the National Industrial Court, the decisions are not conflicting. It simply means that the circumstances are different. Where the circumstances are right, what will happen? The employee will be reinstated. And that 1972 authority in the case of Hills and Parson. Again, is to watch it. When we say section 12 of the Constitution is in conflict with section 2, whatever. The maxim is this, the Latin, and that is the law. And I am quoting, and in order to ensure that we all know that that is the law, I will be quoting no less than Professor Udombana, very distinguished professor, who says that the rule is leges posterius contraris abrogat. That is, where a prior part of the statute in one law, where the prior part conflicts with the subsequent part, what will happen? The subsequent part will prevail. And the authority, this common law decision is Wood and Riley, 1867 law reports 2627, and until the Supreme Court of Nigeria overturns this decision clearly, it remains the law in Nigeria. That means whatever conflict there is between, or whatever ambiguity there is between section 12 of the Constitution and section 2 whatever of the Constitution, the subsequent provision, the law will be applied in favor of the subsequent Constitution. We need to also recall and remember, what we need to remember is that when the lead speaker, the learned professor and SAN, very distinguished professor, talked about, he said something that in other climes they have what we call tribunals. That is true. The National Industrial Court is exercising the jurisdiction, apart from being a Supreme Court of record, it is exercising the jurisdiction of employment law tribunal, which is the vehicle through which the state, that is the country, the state is trying to bring socio-economic justice to the people. How is it doing that? Section 17 of our Constitution, which we say Section 17 of the Constitution, which is social objective, directive principle, we say it's not binding. But it says that, I will read it. It says, with your kind permission, the state shall direct its policies towards ensuring that all citizens have opportunities to secure adequate means of livelihood and suitable employment. Conditions of work are just and humane. In addition to all other things it says. That is what section. And there are, some people will say this provision is not binding, but there are cases, including FRN and AG Ondo and AG Federation, which says where there is a subsequent law or where there is any law which gives effect to this provision, then they will become binding. Isn't that the rule? But so what has happened? The National Assembly then passed the law and say that the National Industrial Court will enforce socio-economic justice through the expansion of its jurisdiction. Thank you very much.
Another round of applause. It can only get better. Well, at this stage, we quickly go to, again, Team B for their closing remarks, and then please comment, questions, and then we're back.
Thank you very much. In closing, I would like to address two issues raised by the other side. And the first one is the point that was made about conflicting decisions. And my simple answer to that is, what I see with the greatest respect to the erudite debaters on the other side is an attempt to confuse and conflate two distinct issues. The issue of the adoption of international best practices is separate and distinct with its implementation. There may be challenges, there may be issues, right? But those two should not be conflated. As a matter of fact, we see on a daily basis conflicting decisions from the Supreme Court. The Supreme Court does not apply international best practices, but they give conflicting decisions. We see those conflicting decisions at the Court of Appeal. So that cannot be the reason to make an argument that the adoption of international best practice is unwarranted. It cannot be. It cannot be. The second point that was made about judicial precedent, the truth of the matter is that Section 7(6) of the National Industrial Court Act says that international best practice shall be a matter of fact. So what it means is that if you want to rely on it, it is not law, it is fact. You have to plead it, you have to adduce evidence to support, and it may be upheld in one case and not upheld in the other, depending on the ability of the claimant to plead it and then support it with good evidence. So again, that cannot be the reason to argue that international best practice, its adoption is unwarranted. And then I want to leave you with this, because the point has also been made that, you know, master-servant relationship, elevation of that relationship and all of that. That is not where labor law is today. And I want to leave you with the very wise words of Arturo Bronstein in his seminal work, International and Comparative Labor Law, Current Challenges, where he said, and I quote, "The goal of labor law is to ensure that no employer can be allowed to impose and no worker can be allowed to accept conditions of work which fall below what is understood to be a decent threshold in a given society at any given time." Thus, labor law is not just a means of regulating the exchange between labor and capital, the same way civil or commercial law does regulate civil or commercial contracts. Rather, it is a means, indeed it is the principal means, to operationalize what the ILO nowadays defines as decent work. So if anyone is saying to you that the adoption of international best practice is unwarranted, the person is telling you that Nigerian employees are not entitled to decent work. That's simply what the person is saying to you. And you must not accept that. Thank you very much.
A round of applause. Okay. So it's time now to come to a panel of judges. But before I throw it to the panel of judges, please permit me to ask each side a question. I interrogate further their submission in support or against the proposition today. So with Team A, my question, and it's unfortunate Ms. Akeredolu saying is not here. I listened when she made a distinction or tried to make a distinction that the industrial court decision in Owolade and Ajib, where the court made some clarification in relation to the international best practices. And relating it to Chukwuma and Shell is an older Supreme Court case. I would want him to reconcile, and interestingly, quite familiar with Owolade and Ajib, is one decision that from time to time I've had to refer to as being the decision where the industrial court, per Kaim J, then, as he then was, now the president of the court, had an opportunity to explain what it means for the court to depart from common law. That sections 13, 14, 16, and I think 19 of their establishment statute, the community reading gave them the right to depart from the common law interpretation that we continue to hold at every point in time. That, for example, a master can wake up one day and say that I'm not happy with employee, you can go without a reason. And that ultimately, when the court finds that that termination was not properly done, the courts, based on the evaluation of the fact, can decide that it would not suffice the justice of the case to just give him the quantum that ordinarily would have been entitled to if it was properly terminated. That equity says you can depart from common law, the rigidity of common law. So if on the fact, 1 year would suffice, 2 years, based on the fact, the court can. So I would want us to reconcile that, and I want your thoughts. But more importantly, and I'd like to call attention to this, the Court of Appeal, as far back as 2018, has made a decision that indeed the industrial court should be wary of following cases from the higher courts that came pre-third alteration. Nasarawa State Specialist Management Board versus Mohammed. That's the Court of Appeal, not the industrial court. So the Court of Appeal, higher court, has even warned the lower courts or giving more like a hint that you can depart from following those other cases if they don't follow the social circumstances that led to the enactment of, the coming into play of the third alteration. So I don't know. I will lead you to bets. In the meantime, my question to Team B, I'm not listening. I'm not convinced. Personally, that we have been able to address the point, a critical point in adversarial style of litigation or resolution of disputes that we rated the common law that we have in our jurisdiction, to the effect that there must be certainty in the law. There must be certainty. A man approaching the court should be able to tell that this is where the court will lean. In a similar fact circumstance, this is what is made. It appears to me that the industrial court seems to have the latitude, depending on if Mr. Wingate comes before the court to say he wasn't properly terminated and he addresses this and all of that, and then the court can find that, oh, it wasn't served a notice. Sorry, the notice says didn't give any reason. So for that, it is wrongful. And in some other case, so put it this way, indeed there are conflicting decisions around that. I am not aware that there is an overwhelming consensus or unanimity as of today that you can indeed terminate without a reason. So I would want you to address that in light of the settled proposition of stare decisis, certainty of the law. So where do we start with? Then please, you can ask your questions.
Okay, thank you very much for the question. The way I see it is this. In the case of British Airways versus Maconjola, I think it's a 1993 case, the courts awarded 2 years damages, and some NIC courts have relied on that decision to give 2 years salary for where they found the termination wrongful. And it is interesting to note that a couple of Court of Appeal decisions have departed from that. They've held that once you terminate an employee's employment, is only entitled to 1 month's salary. And in point of fact, in Cato and CBN, the Supreme Court said it clearly. And what the Supreme Court said was that once you terminate, you can't bring the thought of defamation. The claimant said they terminated his employment and it was defamatory and he claimed damages and it was awarded. But the Supreme Court said no. In termination cases, the contract of employment is the bedrock of your case. The terms and the responsibilities and the rights of the parties is limited to the contracts of employment or the terms and conditions of the employment. So we can't be going into other extraneous documents like international best practices to determine the rights of a party and all of that. So to answer your question in summary, my position is that the Supreme Court has held clearly, even that the Court of Appeal has also said something in the same position too, that when it comes to employment, in Oak case, the Supreme Court, the Court of Appeal did not agree with the salary that was awarded. In Coca-Cola and Akusoya, they awarded 1 year salary, 17 million naira. The Court of Appeal said no, she was entitled to 1 month salary. In Batlewin, the court awarded $190-something thousand, and the court reduced it to $20-something thousand, 1 month salary. So the Court of Appeal has also held that. So my position is that the law is clear. Your contract of employment is the bedrock of an employment case. If you want to put other terms by international best practices, when you go for interviews, negotiate with your employer and put all those terms there. But for employment cases, your contract of employment is the bedrock. You can change your HR policy. When you have town hall meetings, law firms have town hall meetings. You can have HR, we have HR departments that know about compliance and all these issues. That's the way to change policy. You change your handbook, you change your contract of employment. A company can start it. The way we're talking about sustainability and governance, that companies are changing. All this, you are in hairs. Let us see your employee handbook. Does it have all these international best practices there, saying that you can do all these things and all that? Then if anybody terminates your employment, then you go and enforce your contract of employment. So the law has to be certain, like Prof said. The law must be certain. We must be able to advise our clients with certainty. We can't just go to court today. And one more thing I forgot to say when I was talking earlier, that I've done a case before personally, the Emmanuel Ejiogu case versus Meridu, where international best practice was adopted. I was the one that argued the case. But there are local statutes. There's a Lagos state law. There's a federal law. So I cannot challenge that kind of position because it was adopted commonsensically, logically, and statutorily. But you can't bring one convention from somewhere that even the employer is not aware of. You are ambushing the employer.
Just by way of a footnote, you might call it capitalist point of view. You might call it investment point of view. Looking at a situation where you enter into a contract that I will pay you 1 month's salary in lieu of notice. That is the agreement. At the end of the exercise, you are terminated, or there's a termination, and you end up with about 3 or 4 years salary. Sometimes as high as 20 million, 30 million, 40 million. Those of you who are here are either investors or potential investors in public quoted companies. His own company, there's something called bottom line in terms of income and expenditure. Now, when those funds, damages are paid, it's not coming from the purse of the managing director. It's coming from the bottom line of the company. At the end of the day, you deduct all those damages and it will impact on the bottom line in terms of how much you are paid as a dividend. Where I'm going is that we must protect workers, no doubt about that. But how about the investors who also create employment? Is it a crime for an investor to create employment and now have to pay a lot of damages? What I want to leave with us is that best practices, unfair labor practices, and so on and so forth, justice is not just one-way traffic. It is not two-way traffic. It is three-way traffic. Employee deserves justice. Employer and investor deserve justice. The court and its end users deserve justice in terms of certainty.
Thank you. Nothing disarms as much as the debater, even taking it personal. So they kept referring to his personal. Please.
Again, and again. I agree with the last speaker that justice is a three-way traffic. In other words, in labor law and labor relations, we have what we call the social partners: the workers, the employers, government. They are all stakeholders. When we keep talking about international best practices and all this, we must remember, I said, Nigeria is a member of Committee of Nations, 187-member International Labour Organization, the most successful of UN organizations. The way the conventions and the recommendations and all the other sources produce that, the three social partners agree, they meet, they debate, is by 2/3 majority. So there is no imposition anywhere. It is the parties themselves that produce these standards. So when we now come home to the issue of how you apply it, when you apply it, I will put the blame squarely at the door of lawyers. Because you are not aware, you realize that labor law is an elective. Many don't know about it. So when you come, you use the general principles of law to an area that requires specific and special knowledge. So what it means, like I used to tell my students, that any lawyer, anybody who has agreed to read law has sentenced himself or herself to a lifetime of reading. We must all go back to the classroom and study labor law. The National Industrial Court needs to be helped to chart this new jurisprudence. It's not an unwarranted expansion. Thank you.
Thank you so much.
So,
three questions, please.
Afolabi, I will answer the question that you asked. And I think it's important to draw a distinction between law, treatment of law, and fact, right? You can have conflicting decisions with respect to the law, but there will always be different outcomes in applying law to different sets of facts. So the law today is that If you're able to go to court and establish that there is an international best practice that is applicable to you, the court will enforce it. That's the law. There is no controversy about that. But whether you're going to be able to apply that principle to the facts of your case is a different matter. In 1993, in the case of British Airways and Makonjoala, there was no international best practice. But the Court of Appeal awarded damages of 2 years' wages because of the peculiar facts of that case. The Court of Appeal said that if you dismiss an employee in circumstances that impact or adversely affect the integrity of that employee, it will not be just to just say, take 1 month. This is not conflicting. It is the outcome. Even in England, the case that my co-debater referred to, Hill and Parsons, in that case, Lord Denning issued an injunction in view of specific performance for a contract of service. That had not happened. Because the general law is that you cannot force a willing employee on an unwilling employer. But because of the peculiar facts of that case, the Court of Appeal in England departed from the general rule and granted an injunction. So let's be clear. When we talk about conflict, there will always be different outcomes when you are applying law, principles of law to different sets of facts. And that is what we have. But I don't see any conflict in the law. Today, what the Court of Appeal has said, what the NIC has said, is simply this. The NIC has jurisdiction to apply international best practice. It is a matter of fact. If you plead it and you're able to support it with credible evidence, we are going to apply it to you. There is no conflict about that. Thank you.
Thank you. Questions? Sorry. Okay. Let me see. Show of hands. How many questions? Okay. So we would only be able to take 3 questions. And I'm not sure we have that luxury of time. The organizers are saying that I should take this. Oh, okay. I think it's only fair. We'll take 4 questions. Maybe when next you have this, you wouldn't ask me to be the moderator. Please, would you have to allow them? So, Bayo, emeritus and former chairman. Let's start with the emeritus former chairman, Mr. Ogule.
No, I'm Paul Omoijade. Permit me to stand on the well laid down protocol. The enthronement of application of international best practice is a welcome development. 1, I work in a bank for 31 years. And the first day I joined the employment, I was given the collective agreement between Nubife and the Nigerian Employer Association of Banks and Allied Institutions. And you discover that that collective agreement conforms with acceptable international standard. I'll give you an example. Under that collective agreement, you cannot terminate an employee except you have given that employee 2 warning letters, and on the 3rd occasion before you can terminate, which conform to ILO recommendation 166. And that is ILO recommendation 166, paragraph 7. And recently, you analyzed one of the cases I dealt with, Amanze and Union Bank. And that matter, they said the employee did not perform. And because of that, she was not confirmed. And we pleaded the handbook of that bank. And the handbook provides that if before 3 months before the time of confirmation, and the employee have not performed up to standard, you should notify the staff to take remedial steps. The employer didn't do that. They went ahead and terminated the staff after about 2 years in employment. I give you that conflict also with the ILO recommendation 166, which the employer incorporated in their handbook. And the speakers also alluded to the archaic nature of our labor laws. If you look at the Labor Act, section 20, that dealt with redundancy. If you look at the Industrial Relations Act in England, the payments that should be made upon attainment of certain period in employment or years is specified. But in our own legislation, that part was removed. But you discover that the collective agreement in the banking industry and some other areas, they went ahead and analyzed what should be paid. So, if you make mention of section 254C and section 12, section in Skybank and EWU, the Supreme Court has said that the word notwithstanding used in that provision means that that section is self-fulfilling. It's self-fulfilling. It's not dependent on any section of the Constitution. So I stop here, meanwhile, and I welcome the enthronement of the regime.
Let's just take all the comments. Thank you, sir. I mean, worked in the bank 31 years, understandably, you should support enthronement of it.
Thank you very much, sir. I stand on non-existing protocols. My question is actually directed to Team B, and more specifically, Professor Agomo. Man, when you are addressing the audience, you refer to the fact that labor law is more of politics, economy, and customary. Now, my question is, I have two questions. Considering the fact that most of all these international best practices are foreign laws, custom, and traditions, in the circumstance whereby, let's take, for example, the LBGT, in the circumstance that the rights of LBGTs is being upheld by international best practices, and our law and custom is against that. And don't forget that Nigeria is an highly conservative country. Will you still support the idea where such right should be imported into our country by the NIC? And also, new colonialism is happening. And the international best practices is controlled by the West. When I mean the EU and others. Don't you think is a room, the Constitution has given the NIC, and as the question goes, unwarranted room to import what may be catastrophic, for us not to swallow for us not to chew what we can't swallow in our country? Thank you.
Sorry, come. Yes, thank you very much, Radical View, and we'll come to that. But apologies. Well, I think it's important to state that it's a privilege, and then we are grateful to have in our presence with us Honorable Justice Subaka of the National Industrial Court, Lagos, and Honorable Justice Elizabeth Hodgie. Thank you, my lords, for coming. Well, I'm not sure when my lords walked in, but I issued a disclaimer when we started that whatever views shared there do not necessarily represent the personal views of the debaters in relation to the otherwise laudable adjudicatory work that the industrial court is doing. So I think we're just debating. We'll take it in context.
Good afternoon, everyone. Yes, I think it's good that my question follows his. There are similar issues that I want to raise, but in a more broader and policy perspective. So we have a system of separation of powers, and there's a reason for that. Lawmaking is assigned to the legislative branch for a specific reason. For some reason, I think Section 254, my personal opinion is somebody was just being lazy. We don't want to update our laws piecemeal. So let's just hand it over to the courts. But there's a reason why the courts are not best suited for making laws. There's debate gauging the social, economic, or cultural or customary changes in a society, which the legislature does. It does public hearings before it passes laws. It debates specific languages and clauses, which the courts are not built for. But here we are telling the court to determine what the law is because of the discretion as to what components. Even the keynote speaker, Honorable Justice Galadima, enumerated components of IBP that were quite broad, and I was a bit surprised. But I'm sure even some Team B members will not go that far. So I would say, what do you think are the safeguards that we can have to ensure that this court that is given this power to almost make law is able to do so in a manner that doesn't do more harm than good? Okay, so short summary is, I think Section 254 was a shorthand way of trying to cure many problems that are wrong with our archaic and deficient legislative framework for employment laws. But I don't think the courts is best suited for lawmaking, which is what 254 essentially gives them the powers to do. So how do we ensure that in exercising these powers, it's done in a way that does more good than harm?
My Lord, Honorable Justice Oji, Honorable Justice well, I think this is the only place I can perhaps ask the court a question. Yes, my Lord. Sorry, no, my Lord. Yes, my Honorable Justice Oji, PhD. So a round of applause for Honorable Justice Oji.
Good afternoon, ladies and gentlemen, and good afternoon, the erudite discussants, and Mr. Kuti, SAN, the moderator. First, we want to express joy in seeing this kind of discourse, where issues relating to our common interest are brought up for us to share our views. And in doing that, we are all better off. Both the judges, the lawyers, everybody, we are all better off. And that was why, even though we got notice to be here this afternoon, we got it very late yesterday. I don't know what happened with the communications, but the presiding judge in Lagos Division called us about 4 p.m. to show us a letter from the president that this occasion will be holding today, and requesting that the PJ should be here to represent him. Unfortunately, the PJ is indisposed and told us late yesterday to make effort to come. And then, of course, we had scheduled matters for today. So we had to hear them. And in fact, I had to stand down one of them to 2 p.m. so that, we'll quickly rush to this place, make an appearance, and then return to the duties. So the discussions have been quite robust. We came in while Professor Agoma was speaking. And so we have the privilege of what the 5 speakers said, except that of Professor Sipiton, which we missed. And then, of course, that of the lead speaker. So we don't have a privilege of those ones, but I'm sure that it's all in line with the discuss. For us as judges of the NIC, we are not in a good position to take stands. So we can only listen to both panels and make deductions that will help us in our adjudication. But what I would like to point at, and our president have said that severally, that the courts is not just for employees. And those who practice in the courts will see that both employers and employees, that get the opportunity to make their case. And then judgment decided in favor of whichever side. And employees, some of them will testify that where the cases are not proven, even when the matters are undefended by the employers, and the matter is not established, that the courts, will always do the right thing. There's a question. The last comment said, he feels the court is not best suited. What I don't understand is whether he means the court as National Industrial Court not being suited to make laws, or whether the courts as a system in Nigeria are not suited. Because, we are all students and we all taught that judges make laws in the circumstances where they should. And so if the National Industrial Court is a superior court of record, as stated by the Constitution, then they should also have that cloak, generally. Now, coming to specific terms, and I don't understand the question, if he meant that the National Industrial Court as a court itself, then that is where I would fault it, because the court is a court of superior record. The judges are as qualified as the judges of the other courts. And so I should think that they also would be in a position to make laws where need be in accordance with the law. So that would be my response to that viewpoint. So I think that if the National Industrial Court is a court of record, then it also has the capacity to do what courts do. And I don't think we've checked in that responsibility in any way. Then I'll just respond to, this very naughty issue of Section 12 of the NIC Act that speaks about not being bound by the Evidence Act. To say that the law itself says we are bound by the Evidence Act, and we can only deviate where in the interest of justice. And what is in the interest of justice would depend, of course, on the circumstances of the case. And I'll give an example. I had a matter where 3 police officers were dismissed and they were in court. And all the documents they needed to prove their case were police documents, which should be certified true copies. And these officers were in court, and all they had were photocopies of the signals, of the guard room decision, all the things they needed were all photocopies. And then, of course, the issue that these are not admissible documents because they are not certified was raised. And the police officer said, yes, we should tender certified true copies. The first day we went, we were beaten. The second day we went, they told us they would lock us up. The third day we went, we had to run for our lives. So what do we do to the case of these persons? Whether rightly or wrongly dismissed, how do you establish it without looking at those documents? So in that matter, I looked at it and I said, in the interest of justice, there's no way justice will be done to these 3 officers if we do not look at the documents they have. And so, in that circumstance, we had to, following the authority of the acts establishing the courts, we had to say, well, we are bound by the Evidence Act. But in this case, if we stick to this Evidence Act, these people will go without justice. We won't even hear the matter on the merits. So we have such cases, and the courts, we are not quick to set aside the Evidence Act. We do it in exceptional circumstances when there is need to do that. So, of course, all the other issues, we can't join issues on them, but we thank you for, for this discourse. And we're glad we came in when we did. So we're able to hear some of the opinions, which I'm sure will also help us, when we go back to look at ourselves and, do better. Thank you.
Yes, I'll just be very brief because my colleague has spoken on some of the issues. Good afternoon, everybody. Professor Gomo, Shupito, I've met you in Unilag and the other learned people here. This issue of Section 12, most times people overflog this issue, that the National Industrial Court does not apply no, that's not the situation. It's only when it has to do with in the interest of justice. It's like tendering some documents in the court, and then the certificate of compliance is not there. There is no judge, National Industrial Court, that will accept those documents. We cannot say Section 84.4 is no longer applicable because it's the interest of justice. No. So you see that we apply the Evidence Act like any other court of superior record, but only depart in some cases. Even sometimes, some people come to court with just photocopies, and I tell you, go and bring some original. I'm not going to accept all photocopy because we are relying on Section 12A to depart in the interest of justice. Then the issue of these oak pensions decided by the Court of Appeal from National Industrial Courts, apart from the international best practice aspect that was rejected, every other relief, I think the Court of Appeal agreed with the National Industrial Court on that issue. Thank you.
Again, I'll ask that a resounding applause for the court. My Lord, we are indeed very sorry that the notice came or got to the court very late. Apologies for that. But more importantly, I think the lesson, the takeaway from it is, again, to commend the court that despite the late notification, as at yesterday, the court is still here. It shows that it's indeed a court that is determined to deepen its jurisprudence in engaging in such interaction as this. Please, a round of applause again. No, so I'll just, and it's quite interesting that Honorable Justice Oji is here, PhD. Honorable Justice Oji is a professor of law, by the way. And the argument has been made, it's a court for the employee. I've had 3 judgments. I've done 3 cases before Honorable Justice Oji. 2 for employees, 1 for employer. I lost the 2 for the employees. The 1 for the employer, I got judgments. Do the maths. No, so please, a round of applause.
Good afternoon, everyone. And let me stand on the, as Nigerians who say, on the existing protocol, just to save time. I want to specifically join issues with Mr. Farouk Abbas, who made a comment that I wasn't quite comfortable with. I don't know whether it was intended as a rhetoric, but he said that an employee should try to negotiate IBP in his or her employment, letter of employment. I think, with due respect, that is quite absurd, to say the least. Because if we approach this controversy on IBP from the point that as lawyers, we all believe that the essence of the law is to be an organic instrument that at every point in time should reflect what is the best for the society. We may not break so much sweat arguing whether international best practice as enthroned and as entrenched in the Constitution should be applied. I don't think it was a lazy approach by the legislators. The point has been made that the courts are empowered to adopt international best practice. So a reasonable tribunal or court should know what to adopt and what not to adopt. And cases are won based on law and fact. And then if you look at the historical trajectory of employment law in Nigeria, for decades, employers had their way. They wake up in the morning, if they don't like your face, they ask you to go. And you go, and nobody challenged that. Court, even the Supreme Court, endorsed that. Suddenly, we woke up and realized that things have changed. Let there be a little balance. Now, I mean, there had been hues and cry how National Industrial Court is a court of employees. I don't think it's true. Because just like Leonard Silk said, people lose cases for employees every day. If you are not able to prove your case, then so be it. It has to
be anchored on fact. I'll give you an example on redundancy, and I'll end there. As a matter of fact, I have a case before NIC, a personal case on redundancy. The fact is this: the law needs to be developed. For instance, some employers don't know the elements of redundancy. So if you wake up and you have an employee that it happens, a workplace can be toxic, a particular employee, you just want to ask him out. Most times it could be a performing employee who you can't lay your hands on non-performance, you can't lay your hands on lateness, you can't lay your hand on gross misconduct, which can make you to dismiss him. You can rely on redundancy and say, oh, dear Mr. X, your employment with XYZ company has been rendered redundant. Oh, you take 10 naira and go. Now, if Mr. X approaches the court to challenge that, a defendant can come and say, oh, section this of the employment letter says I can ask him to go. But if the court does not interrogate the essence, the question should be, what are the indices? Because if you go to the Labor Act, it pronounces what you should do. Why will redundancy be declared? Excess manpower, automation of, this work that you were doing before can now be done by a machine and all that. So if the court does not make an interrogation on what is the reason for termination, if the court takes that simplistic approach of an employer has a right to hire and fire, or that he need not give reason, then that means employers will have so much power to the point that victimization of employees will be the order of the day. So I take a serious exception to that submission that an employee should negotiate IBP. IBP is an issue of ground norm. It is constitutional. If we need to amend it to say it has overridden Section 12, 345 comes out of Section 12, and it is clear that the court that power has been donated to the court to adopt IBP. The second question will now be, what is IBP? And I don't think that the courts are lazy to understand and interpret what IBP is. And again, coming from an African context, a reasonable tribunal will know what to adopt and what not to adopt. And what are we asking them to do? Before you tell Mr. Okeke to leave, don't just tell him to leave because you feel that his head is too big. Anchor it on competence, on the company is going under, he cannot pay salary again, redundancy, and factualize it. Let there be facts supporting it. What employers are afraid of is that most employers are afraid to come out clean as to why Mr. Kolade is asked to leave. I'll leave it at this. Thank you.
But again, it's only fit to say that. Also, thank you very much. If you are not a member of ELLAN, it tells you the quality of advocacy and depth of reasoning you are missing when you are not on that platform when they engage in such a debate. Thank you very much, also. Time colloquially is fast spent, and is not our friend. Yeah, so we just, I don't know, just last thoughts, one minute on anything said, and then we'll come back to the audience to tell us the verdict. I take it that the verdict is in now, right? Show of hand, is the verdict in? Yes, so that is what. Yes. Okay, yes, Paul.
I was asking this adoption of, thank you very much for the question, but I think that the last speaker has more or less actually answered it. The fact that I said international best practices is based on customary, I didn't say such thing. What I said that international best practices, it's not nebulous. When you made it, it's not something that you don't know about. That's the closest stuff you can find is International Labour Organization. The conventions that is product of the three parties, they speak a lot about it. they come out. If it's convention, if we all agree, two-thirds majority becomes a convention. If they don't agree, it becomes a recommendation. And the application of it in relation to individual countries is subject to specific conditions, local conditions. So there is no general imposition, local conditions. So each nation can adapt it to suit their specific circumstances. Nigeria is a conservative country. Nigeria has its what you call what it feels about alternative lifestyle or whatever. I don't think it has been an issue before the National Industrial Court. If ever comes to National Industrial Court, they'll have to deal with it. But remember, issue with Delhi, because human rights has become part of labor. So you have to deal with issues of human rights as it affects labor, regardless of what you and I feel as our personal viewpoints. Thank you.
Thank you, Prof. Anything?
Okay, thank you for, I think there are two questions I want to respond to. I'll respond to Nonso's questions first. He said my proposition that employees should negotiate IBP is absurd. Well, I disagree with you, but for personal reasons, you've said the reason why you hold that view. And I'm glad that my learned former president and senior here made some very brilliant comments when he was talking. He said, as a banker, the bank gave him collective agreement. And the collective agreement had terms that reflected about 2 conventions. So what it shows is that in their organizations, they had brilliant and forward-thinking people. Our job as lawyers is not just to be arguing the law of 1970-something, 1980-something. We can, in our own sphere of employment, we can also make changes. We can make changes at the National Assembly. How many of us here have attended any public hearing at the National Assembly and submit memoranda whenever they ask us in the newspaper? So as lawyers, we should contribute towards changing the law. And we're not saying that we shouldn't change the law. I gave an example of a case that I worked on personally, that I argued at the court, and we used international best practices that were adopted. In Fawayemi's case, they did the same thing. So in this company now, they followed the international convention. So as companies, as in-house counsel, if you go for interview, they ask you, do you have any question for me? You can ask them. These are international best practices. What is your view on this? What do you do? What's your stand on this? So that's what I meant. And it's not absurd, it's not unusual, it's not unheard of, because he gave us 2 examples. And I'm sure there are other companies. We also advise companies review handbook. And we tell them it's not in line with international best practices. And he mentioned the case, they brought the handbook, the company did not comply with the handbook. In Sahara Energy as well, same thing. The handbook of the company says that when you want to interview an employee to face a panel, you must record it in writing and orally. But you said you faced a panel, you didn't record it, you didn't do anything, you now took her to court, and she won you in court. And the Court of Appeal upheld the damages that was given to her because you didn't follow your book. So employment law is bedrock, is your terms, your handbook, and all that. So as we are in there, we should change it. Law is not about sentiment, it's not about emotions, it's about logic and common sense and structure. And to now close, my closing, I answered this question. I want to give you my closing, which is 1 minute. My closing is this. For the sake of argument, let's assume that Section 254C gives the National Industrial Court the power to adopt labor treaties that have been ratified and not domesticated for labor matters. So does it mean that for terrorism matters, so National Industrial Court will be applying treaties without domestication? But when it comes to Federal High Court and other court, when it comes to treaties on terrorism, on rape, on every other thing, they have to domesticate it. Is it logical for one court to have a structure whereby you can just apply treaties and other courts? And this issue, Skybank and EU, they went to the Supreme Court on case stated because they were not sure. Coca-Cola and Akisoya, we went to the Court of Appeal on case stated. So if we are saying that our interpretation of this section is not agreeing with yours, we have a right. We can take it to the Supreme Court. The duty of the Supreme Court, they have 2 duties. Number 1 is to ensure the consistency of the law. And number 2 is to ensure that courts they follow precedent and to interpret the Constitution. Number 2 is to interpret the Constitution. Number 1 is to ensure consistency in the law. So at the Court of Appeal, we can take it up and say, Court of Appeal, Supreme Court, answer this question for us. So there's nothing personal, let's not get angry about it. We were once employees. We have siblings who are employees, we have wives who are employees, so we're not against the employees, but we have to develop the law. And in developing the law, we have to cross swords and show arguments. So there's nothing personal there, so thank you.
Thank you very much, Farouk. And indeed, there's nothing personal. And nothing draws that home more than the fact that Farouk Abbas did the very first, known case at the Industrial Court, where the Industrial Court had to pronounce as wrongful a termination of a worker or an employee on account of HIV status. I think it should have been there. He didn't get that on common law principle. He got it and relying on this same international. What is the verdict? Overwhelming. I'm not sure. Like I said at the beginning, I mean, the whole idea is that it's not about winning. It is what we're promoting is to have this sort of exchange, an interrogation of what appears settled in the court system in applying international best practices or whatever expansive jurisdiction that the industrial court has been endowed with the promulgation of the third alteration. So I think we're all winners. The verdict is in, and we're all winners. Please, a round of applause for the incredible team on both sides. I call on Mary to please come up and then kindly come and do us the honor of presenting the discussant, the debaters, the incredible panel on both sides. With talking, thank you so much. Thank you so much. Prof. Prof called me INEC. I think that's an indictment on INEC. It's not complimentary to describe me as INEC in the circumstance. Yeah. Please come up. Thank you so much. Yeah. Please come. Let's move. Okay. Yes. Where are the? Let's bring in. Yes. Please come. Please come. Yeah.
I don't really need this. I'm sure my voice can.
Oh, fantastic. You can project it. Yes. On behalf of ELLAN.
Thank you very much for coming. Thank you very much for coming. On behalf of ELLAN, thank you so very much for coming.
Photographs.
Thank you so very much for coming. Thank you.
Okay, so photographs now. Trustees, ELLAN, join the speakers, moderator, please. We need to take pictures? Yes. Mary. So how do we? Where's Bio? Where's Bio? Anamadi? Please come. Yes, thank you. Yes, so picture. Where's the photographer?
Okay.
Yeah, it's okay. Thank you very much for being part of the first session. And it's just the first leg of the two sessions in the ELLAN Exchange. A round of applause for yourself.
Before we go, Mr. Kuti, before you go.
Yes.
So this is from us to you. Mr. Kuti is actually a member of ELLAN, And he has been very supportive from when we started in our very early days. And recently he was confirmed with the prestigious position of SAN of Nigeria. Thank you. And so we don't have a lot, so this is a token from us to you. Thank you very much. And thank you for the fantastic moderation. Thank you.
Okay, good afternoon, everyone. So we have another session, which is supposed to be the main event, actually, but we'll take the next 30 minutes on break. If you could please move to the foyer, you'll have some, you'll find some light refreshments there, and then we'll reconvene at 2, hopefully. We're expecting the candidates for the office of the NBA president, and then we'll have another explosive session. Thank you.